before, you attended a webinar, please ask questions. Essentially, the update is that the last vestiges of the non-virtual New York hearing points will become virtual as of next week.
Right, so a week from today, we'll be able to say that every single hearing point, including the last two holdouts, which was the New Windsor hearing point, or Newburgh as it's sometimes referred to, and Allegheny hearing point are now fully virtual. And we think this is really important and something we wanted to share with our clients and all the people that come to these afternoon webinars and watch them on the web. The reason it's important is because New York's massive. From top to bottom, stem to stern, it's 7 hours of driving time from top to bottom. And it's about 7 hours wide, too. It's a really wide state. And the state's hearing points are spread out all amongst the many counties and these great distances. And in the past, Lois Law Firm only went where most of the cases were, and that's really the downtown or downstate New York hearing points, the bottom 12 or 13 hearing points closest to our office in Manhattan and our New Jersey office. And that really worked out for most of our clients because about 80% of all of the cases in the New York workers' compensation system are venued in those hearing points.
That's right, the two largest, Jamaica and Manhattan, really dwarf the amount of cases that come into the other hearing points. And we've had a foothold on those hearing points for quite some time.
In the past, we would sometimes handle cases. A client would ask, "Could you guys go to Binghamton? You go to Syracuse? I got a death case. I want the same attorney on it from beginning to end. Can you do that for us?" But other places in the state we didn't really go to, and that was a little bit frustrating for our clients because they would say, "Hey, we like the way you handle cases downstate. Could you handle them all over the state that way?
Can you please open up a new office
in Buffalo?" And I couldn't convince a partner to go move to Buffalo. Sorry, Buffalo.
You're welcome, everybody here, that I did not move there.
Right, and then the other challenge we have is clients who maybe wanted one attorney to handle all of their cases throughout the entire state. And how can you do that in a state where it's 7 hours driving distance between courthouses?
It's not possible until now.
It's not possible until now. So now all of the courthouses are virtual or will be fully 100% virtual by Monday, March 25th. And when we say fully or 100%, we mean it's mandatory that all attorneys, whether they're going to go there in person or not, check in via the virtual hearing process. So
it's almost like a little nudge to make you appear virtually, because if you're appearing in person, they're going to make you check in virtually.
Right. So the check-in is all going to be virtual. Every single hearing will be virtual, which means you can attend via web conference. There's lots of great information on the board's website, so we're not going to get into the nuts and bolts of how it works. But we have been encouraging our clients to actually come to their hearings.
Right, there's a simple baseline technology requirement for your hardware to access it. The board actually has released an app in the past couple of months so anyone really with a smartphone can attend a hearing, as long as you have the party of interest status or you have the ID and capability. And it's been a great boon for our clients.
Yeah, in fact, we see huge benefits to our clients. And so today, it's been over a year that we've been attending almost every case virtually. And we want to share some information from our experience in doing this. The first thing I want to share is that we recently did a survey for a statewide client. And what we looked at was cycle time, of course, closure rate, number of attorneys, and the average bill. But then we also looked at cases that were handled virtually. And for this client, we've been attending almost everything virtually. We saw a 26% fee and expense reduction for this client in 1 year, which we attribute completely to the virtual hearing process. We have not changed the way we do things here. We still handle cases exactly the same way. I mean,
absolutely,
it is what it is. But we have utterly eliminated the transportation, mileage, attorney time, windshield time, expense for this client in over 90% of their workers' compensation hearings that we attend for them. And so at this year's meeting with the client, I traveled down to Atlanta and I was like, "Hey, look, we're still hitting the ball for you on the way we litigate cases, but look at this. I'm able to show you an actual fee reduction, a year-over-year reduction in what your attorney's charging you for the same volume of cases. That's, to me, something that's very meaningful to a client.
Absolutely. I think the data really emphasizes it, because when the virtual hearing program started, it was really a theory or a hypothesis that we would save the money. Now that we have the actual numbers over a longer than 12-month period, I think the first virtual hearing was in October or November of 2017, essentially there's enough of a sample size for us to determine that, okay, this is a real cost savings to our clients.
Right. We're also seeing less continuances, so cases getting adjourned sort of against our will, and those could be just basic things like, hey, weather.
Right,
you
right.
know?
Snow days, I mean, it especially applies to our upstate population, our increasing footprint there, because, you know, they get the severe weather more so than the downstate hearing points.
Yeah. It's also a lot easier for our witnesses to appear. You know, I've had so many clients over the years tell me, Greg, I am a retailer. I don't want you pulling people to go into court and testify against even a baseless or fraudulent claim. I don't want you pulling somebody out of one of my locations in November, December, January. You know, those are our busy months, Greg. And how frustrating it is to have a defensible case, but, you know, it's such an interruption to the employer or the insured's, you know, workflow to have us pulling out the supervisor or the manager. Now we can tell this person, hey, the case is on for 30 minutes. You're the witness. Here's the time I need you to be just next to a phone, or have your iPhone open and in front of you and have the app open up on the iPhone.
That's right.
And appear virtually. And they don't have to leave the location. They don't have the travel time. They don't have to wait. I mean, how frustrated are clients when they come to court and they're waiting?
Definitely. I mean, there's been a more emphasis too. The judges at these hearing points have had specific training to really call cases faster, right? There's no court reporter. A lot of times we would go in person to court and we'd all be ready, but maybe the court reporter was on a
taking a break, yeah,
right?
Sure.
Or you know, prescribed, you know, time where they would not be in the courtroom, and it eliminates one person. It allows for more seamless transitions. You know, you mentioned the employer witnesses, right? That applies to transportation cases too, or construction clients where they have to be at a particular location, or they're moving from location to location, and committing the amount of time to travel and be at a hearing point can really bog down, you know, the employer's workforce.
Sure. And then the last bonus or benefit I've seen is just safety. I mean, this is a year and a half now, knock on wood. We haven't had an attorney get an offender bender on the way back and forth to court.
Sure.
Or slipping into an icy parking lot, walking into the Queens courthouse. Like, we haven't had that. And it's just safer because 90% of the time we don't do that. So let's talk about what cases we think are right and should be handled virtually. And the reason I'm going through this is really in reaction to some clients who are being told by their counsel, and it's not us, okay, that's telling them, oh, you shouldn't go virtually. That's a fad. It's going to burn itself out. It's not a real thing, or there's no benefit to you. Really wanted to talk about, hey, the system's now statewide. There's no exceptions. It's mandatory, and here's the benefits. And so we think the cases are about 90% of our matters are now being handled virtually. We're only going to court about 8, 9, 10% of the time across our case population.
Right, and it kind of makes sense for the cases where there's not a large dispute, there's no testimony being taken, all the evidence that you need to make your arguments is already in the record. You know, the virtual hearing guidelines actually ask for all parties to submit all the evidence 5 days before the hearing in order to reference it before the judge. So it really does not make sense financially, and as you put it, safety-wise, to bring an attorney to court when you could handle it in-house.
Sure. And for simple admitted accident losses, you know, the issue is what's the wage, the issue is what's the rate, is it what body parts are compensable, or just as simple as putting through a settlement on the record. I mean,
right.
You know, our practice is to always ask for Section 32 to be on the papers, but
right.
Sometimes we have to go in, maybe there's a non-English speaker or other reasons that have us come
Sure.
in. What a waste of time, effort, money, blood, and treasure, and litigation resources. I mean, just what a total waste of time.
Yeah, and to accomplish the same result, right? I mean, it's not just the savings, but, you know, the results we're seeing for a course of a year and a half have not changed whether we're appearing virtually or in person. So
right.
I think it would be cause for concern if we were appearing virtually and getting different results. But,
right.
You know, with the board's annual report for 2018 just coming out, 40% of every hearing over the last year had at least one virtual participant. And it's really not taking any kind of different shape than what we were seeing when we were going to court in person.
Right. So some cases we do not believe are right for a virtual hearing, and we will still appear in person. And our general rule here is appear virtually where you can. and
Right.
go when you can. And so we do find 8, 9, 10% of the typical attorney workload does need to be in person. And we think there's some reasons for that.
Sure. We tell all of our attorneys here, if to use their judgment, if it would help the client to actually appear in person, right? You may need a HIPAA release at that hearing that day, right?
Mhm.
So we want to get the claimant to sign it in our presence.
Right.
We talk about witnesses and shepherding them through the trial process so
Right.
that they feel comfortable and they feel like they have someone to help them navigate through the courtroom. Now, a lot of those things are good examples for why we would want to, and we would always present that opportunity if one of our clients would want us to go. So those are types of cases that.
Sure. And then, less commonly, but, where we want a face-to-face confrontation.
Right.
We're pushing something a certain way, or we're trying to create a leverage point. That's another opportunity. And then those cases where I'm really going to court just so that I can meet my investigator and point out the claimant really carefully and really directly to the investigator and say, this is our person, get on them and follow them. It's
Wink.
a wink, wink. All right. So I've also heard from clients some objections, and I want to talk about them. And these are essentially the justifications that they're being given by their counsel as to why I need to go to every hearing. Okay. Personally, I believe it's because they're just churning, and this is just an easy way to rack up a lot of billable hours in the billable hour environment, or burn through your alternative fee agreement, or however you're billing your client. I mean, frankly, I think these are justifications to just try to run up attorney bills, but that's just my opinion.
Or to avoid the change, right?
Or to avoid the change.
We've heard some practitioners, our competitors in the industry just actually say to us that they will not do this.
I'm not doing it, right?
I
don't care what the rules are. I'm doing what I want. And so one of the chief justifications I've heard is, well, Greg, this is a great opportunity for us to do a face-to-face settlement discussion with our adversary. And the truth is, sometimes that's right. Like that is sometimes the justification. But the majority of the hearings that we attend, if first of all, there's no reason you can't have that settlement discussion before you go to court. Okay?
Absolutely. Right.
Not having good open line of communication with your adversary or opposing counsel before the hearing I think is a mistake. The second thing is a lot of times we go to hearings, I don't get to sit there with the handling primary rainmaking attorney at that law firm.
Who's going to make the final decision? Who's going to execute the paperwork on behalf of the firm? It's typically a coverage attorney.
Well, let's talk about what that means, because
sure.
A per diem attorney is someone who gets paid a per diem.
Right. You might hear the term of counsel, per diem, right? They're essentially retained for that hearing on the day only. Right. And each hearing point has them. It might, in the smaller hearing points, it might be one. Jamaica and Manhattan have like 3 or 4. And it generally gets to the point where you can have the in-person discussion, but the per diem attorney does not have authority because they're not the actual handling attorney.
Right. In other words, this is someone who takes $20, $30, $50 and says per hearing. They grab 50 of them in a day from a bunch of different law firms. They get 1 or 2 or 3 little line blurbs and access to e-case. And they go look up the case. They come into the courtroom and they say what they're going to say. They've got their scripts to kind of go through. And at the end of the hearing, you say to them, hey, grab their elbow and say, can I talk to you outside? Can we talk about settlement? And they'll say, sure, Greg, but just so you know, you can tell me whatever you want, and I'll pass it along, but I'm not the handling attorney. I'm just here for the day.
That's exactly what it is. I'll pass it along. They'll make a note of it in the file, and then we'll have to follow up with the attorney anyway, out of court, right? Because they're not there.
And then the bigger adversaries have a settlement department. So
sure.
You'll see somebody in court and they're from that actual law firm, and they'll go, I don't talk about settlement. Call the office.
Right. We've actually settled some cases. We've actually settled cases faster with the settlement department.
Right.
And that's more of the value that we provide in between the hearings, right? We're not going to sit here and say that we haven't settled a case at a hearing before, but it actually takes a lot of effort on both sides to get that job done, right? The attorney has to come in and actually be prepared to talk settlement, to talk turkey. And, aside from these per diem of counsel cases, sometimes we go into court and it's the actual handling attorney and he or she is not ready to talk settlement. Right? So it's really about the preparation you have. It doesn't stop us from focusing more on settlement in between the hearings, which we certainly have had success doing.
Yeah, I've also heard things like, Greg, I want you to go into court and read the witness or read the claimant. And there might be some validity of that in some circumstances. But it's pretty rare. We have the claimant who comes in with an eye patch and the arm in a sling and 2 crutches, and then walks out of the courtroom. And as soon as they're out of sight of the judge, they take their eye patch off, they put on their dancing shoes and do a jig out of the courthouse. I mean, it's just, less likely. It's in my opinion, it's a pretty remote justification to spend all that time, effort.
Yeah, you know, I
on
mean,
being there.
if there's certainly that kind of desire, right? We'll put on our best suit and we'll look great and, you know, scare the opposing witness and really try to do all the legal tactics that we have to get the right testimony, the right records in the file. But like I said, 90% of those cases, when there's no dispute, you're really saving the bottom line by having an attorney
Yeah,
go virtually.
you know, I think we're very belt and suspenders lawyers here. I think our goal is always to be as prepared as we can be before we walk into the courtroom.
Right.
What happens in that courtroom should really just be the unfolding of our action plan. It really shouldn't be surprises coming in and out of left field. Yeah, we like to throw grenades in their rowboat. Yeah, we like to disturb whatever their action plan is. And, you know, when we'll go to court, that's our intention, create that leverage opportunity. But, you know, the majority of the time, most of the work should be done outside of the courtroom. And we should just be going in there to sort of just put through our action plan and just execute it. And, you know, we really can save our clients a lot of time and a lot of wasted litigation money by going to courts through the virtual process. The other great thing for clients is they can come. You can log in, you can watch the whole case go in and see how your attorneys are doing for you and see how the witnesses appear and see what the judge's demeanor is towards your case. What a great opportunity. And, you know, we've got clients where the adjusters, maybe they're in a TPA, maybe they're in-house, but they're all over the country. Right. And they certainly have never been to a New York workers' compensation hearing before. I'll tell you, there's a big difference between reading a transcript and watching the thing live.
Absolutely.
Right?
To kind of see the process unfold, you know, I like to think of it as like a memorialization of what we've done to get to that point, right? There's nothing new that we're really expecting because, you know, the most prepared attorneys really don't see surprises that often.
Right.
And to have our clients sit in, it's really been nice to, you know, introduce them to the process and see how we work, right? You know, a little glimpse behind the curtain, see how the sausage is made and see how this case is really handled by a true professional.
All right, so I'm hoping that we've sparked some interest or created at least a little bit of controversy or information around this subject for everybody. Again, virtual hearings are going to be mandatory, but now they're going to be statewide. There's not a single exception to the virtual hearing process. Let's go over here, and I'm hoping we have some good questions. I'm going to open up the questions panel. I just see the test question I sent myself before the webinar started.
Similar to the noon webinar, I guess. But
yeah,
you know, I think that if everybody's known what a virtual hearing is, really this particular one is to really announce the breaking news that all 25 hearing points are on board. This is not a fad. It's not going away. And in fact, like the board's push to get this more seamless is really in lockstep with our position in helping our clients, you know, defending employers and making sure that they receive the best possible representation. You know, if anybody came here was looking for some penalties or some coverage,
call us.
You're just going to have to call us, or you know what? There's a great podcast that came out this past month.
Oh, he's got to promote people.
Third Fridays. It's a 201 level side to the 101 level webinar. Please feel free. My partner Tashia Razul was a guest, and she actually just spoke at the CLM conference, so it's really exciting. We hope that you either there or have questions about that as well.
Thanks, everybody. Have a great week.